We've been talking a lot about how Donald Trump's strategy in the Southern District of Florida federal criminal case for Trump's willful retention of national defense information before federal judge Eileen Cannon, Trump's strategy really boils down to graymailing, a form of blackmailing where a criminal defendant basically threatens to expose sensitive national security information unless the charges against them are not dropped. I'm going to show this to the jury. I'm going to show it in open court. I'm going to disclose critical information unless you dismiss these charges against me. And it's for these reasons and those types of tactics that the law has created protections. One of those protections is SIPA, which we talk about a lot here on the MeidasTouch Network, the Classified Information Procedures Act, which creates an entire statutory scheme to prevent criminal defendants from engaging in that conduct, whether it's through SIPA Section 3 protective order, SIPA Section 4's ex parte in-camera hearing between the government and the federal judge where the criminal defendant can't be present, where the government can request that certain documents be withheld from discovery in a criminal case because the national security implications outweigh whether they will be useful or helpful to a criminal defendant, and then a summary or some sort of substitution can be done in its place. There's SIPA Section 5 that relates to the criminal defendant having to disclose what types of classified information they intend to use at a federal criminal trial, so it could be determined whether or not that's permissible or whether a substitution or replacement document needs to be put in its place, or whether the document can even be showed in general. Then there's SIPA Section 6, which provides the procedural framework for how these challenges actually are taking place. But then there's something else that's not just in SIPA cases involving classified information. There is a statute called the Jenks Act, 18 U.S.C. Section 3500, and that relates to government witnesses, inculpatory, not exculpatory evidence, information that's helpful to the government and is more likely to lead to a conviction of a criminal defendant. And because this Jenks material is inculpatory, and by disclosing it early on in a criminal case could result to witness intimidation, harassment, and threats if the criminal defendant knows who's cooperating with the government. Under the applicable Jenks Act statute, 18 U.S.C. Section 3500, the United States government doesn't even have to disclose the reports of the government witnesses until the direct testimony of that government witness is taken. And then the process is the criminal defendant can then request the reports right after the direct examination, so they could use it on cross-examination or then call that witness in their case. This is a fairly developed statutory scheme, nothing controversial here, but nothing happens before Judge Eileen Cannon that follows these steps and regular procedures. And one of the ways that Donald Trump is trying to get at this material, we've talked about it on another video as it relates to SIPA, the Classified Information Procedures Act, where despite it being abundantly clear in the statutory text and all of the case law that a criminal defendant's lawyers can't be at the SIPA Section 4 hearings, it's just the government and the judge, Donald Trump has made a request that his lawyers appear at this hearing, look at this classified information, which would basically render all of SIPA useless if that was permitted. Judge Cannon said that she is going to consider Donald Trump's request. She's held like a separate SIPA hearing at the end of January before the other SIPA hearings take place in February, instead of outright rejecting Donald Trump's request, which by law she should do. But she's been framing these as paperless scheduling orders before the actual SIPA hearing takes place, so that at this stage, until she holds the hearing, that's unlawful and invalid. Special counsel Jack Smith cannot file an interlocutory appeal yet to the 11th Circuit to overturn what Judge Cannon is doing. She's delaying. There's this other interesting fight that's taking place before Judge Eileen Cannon, and it may seem complicated, but let me uncomplicate what's happened. So Donald Trump filed a motion, and Donald Trump's motion was filed as, and this is how he styled it. Trump filed a motion before Judge Cannon that was called Motion for Temporary Leave to File Redacted Brief. In other words, Trump acting like, Judge Cannon, please give me permission so I could file a brief that is redacted so we protect certain information pursuant to SEPA and the Jenks statute, the Jenks Act. So we're going to file this redacted brief. And that's how it's framed. And it's very fraudulently framed like that. A lot of mischief there in the framing, as Special Counsel Jack Smith points out, because even though Trump is calling it in his motion a motion for leave to file a redacted brief, making it seem like, oh, we're just redacting the names here. No, what Donald Trump is actually doing is, in effect, a motion to disclose discovery material that's confidential and classified under SEPA Section 3 protective order and under the overall protective order in the case. Trump wants to redact very little. What Trump's actually requesting of Judge Eileen Cannon in Trump's motion for temporary leave to file a redacted brief is actually to disclose the names publicly of the government's informants, of the government's witnesses, so that the MAGA base can then attack these witnesses, harass them, and go after them. But rather than calling it a motion to disclose the identities, which is what Trump was really seeking, Trump instead was calling it a motion for leave to file a redacted brief, making it seem like he's protecting the names. So Special Counsel Jack Smith filed an opposition and doesn't adopt the title that Trump's using. Special Counsel Jack Smith's motion is called the government's response regarding the defense motion to disclose discovery material. And because Trump's trying to reveal the names of these government assets, of this inculpatory material that didn't have to be released by the government until the time of trial, the government disclosed this information early because they were going above and beyond what their obligations are. But then Trump is now saying, I want to reveal those names to the public, but I'm going to act like I'm not doing it by calling it a redacted filing. So here's what Jack Smith says. 2 days ago, the defendants filed motions to compel discovery that are replete, referring to Trump, replete with mischaracterizations and baseless arguments. Concurrently, defendant Trump filed a motion for temporary leave to file a redacted brief that was joined by the other defendants, Walt T. Nauta and Carlos de Oliveira. The government supports full transparency of the record consistent with witness safety, national security, and the court's protective order, in part because the transparency will expose the defendants' distortions and the factual and legal landscape in their motions to compel. Nevertheless, out of concern for witness safety and the reasons explained below, the government opposes the motion for temporary leave to file redacted brief. In effect, it is a motion to disclose discovery material that is subject to this court's protective order, protecting those identities, to the limited extent that the motions to compel or their exhibits identify any prospective government witnesses, constitute Jenks Act material, these witness reports, or contain additional discrete and sensitive information specified below. So then the brief does a brief overview of what the Jenks Act 18 U.S.C. Section 3500 is, which I described to you, that it's these reports of government witnesses that don't have to be disclosed until the direct examination of the witness concludes and a motion is made by the criminal defendant. And then Special Counsel Jack Smith says these concerns are at play right now. The reason why these government reports are not disclosed until the trial and the examination takes place is to protect these witnesses. So Judge Cannon, even though we've turned this over to Donald Trump so we could go further than what our discovery obligations are, we still need to follow 18 U.S.C. Section 3500A. Accordingly, the government objects to the unsealing or public dissemination of any information that contains this information of potential government witnesses or personal identifying information or what they've said. Trump can have it, just we can't publish this publicly yet because it's going to result in threats and intimidation to the witnesses. Then Special Counsel Jack Smith lays out where those exhibits are and what those documents are that Trump wants to try to release to the public. And Special Counsel Jack Smith says, look, the government has no objection to the public filing of anything beyond the protections of witness safety, but we need to make sure our witnesses are protected. And what was really smart and sophisticated about what Jack Smith did here was reframing the way Trump was framing it. Trump, again, deceitfully calling it, Your Honor, I would just like permission to publish redacted, to redact this information, a limited redaction. And then Jack Smith's like, no, you're trying to do more gray mailing. So ultimately, Judge Cannon's going to have to make rulings soon. She's done all these paperless orders, moving these dates, but not actually making a ruling. She's going to have to rule. And once she rules, if she rules the wrong way, that's when Jack Smith's finally going to go to the 11th Circuit Court of Appeal. But she needs to make a ruling, and Jack Smith and his team are right on the law here. This isn't controversial, but we're dealing with Judge Eileen Cannon, who previously, back in the other Trump case in 2022, was the first judge ever in American history to assert equitable jurisdiction over a duly authorized search warrant, the one that was executed at Mar-A-Lago, by claiming that Trump was special, and that she was reversed in 2 orders by the 11th Circuit. So we'll see what Cannon does here, but that's the framework of what's going on. I'm Ben Meiselas from the MeidasTouch Network. Hopefully that clarifies the process and the subtle mischief Trump and his lawyers are trying to work to harass and intimidate witnesses. And when Special Counsel Jack Smith goes above and beyond, how Trump tries to use it against him. Hit subscribe. We're on our way to 2 million subscribers thanks to your support, and have an excellent day. Hit subscribe now.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.